The next case is Hooks versus the state of Florida. Please proceed.
May it please the court, my name is Danielle Jordan. I'm an assistant public defender for the Second Judicial Circuit, and I'm here today on behalf of Mr. Sylvester Hooks, the petitioner. I have previously reserved 5 minutes for rebuttal. This case is before the court on a FRERETA issue. The First District Court of Appeal, in affirming Mr. Hooks' convictions and sentences, certified a question of great public importance. And that question is a FRERETA inquiry invalid if the court does not explicitly inquire as to the defendant's age, experience, and understanding of the rules of criminal procedure? Believing the question was too narrowly focused, petitioner reformulated the question addressing what was a particularly troubling aspect of this case, and which has broad implications in our system today, where because of judicial economy and even technology, we're moving more towards using forms and videos instead of having an actual oral discourse with the clients or the defendants. And that reformulated question was, does a written form, which sets forth the dangers of self-representation and the benefits of having counsel without any inquiry by the trial court as to age, education, etc., does that fail to satisfy the rule?
What does age and education have to do with it?
Age and education are indicators that the court could use to determine whether or not a defendant has the knowledge or is knowingly and intelligently waiving a right. So these are questions that need to be asked of a defendant to find out what's his circumstances. How old are you? How far have you gone in school? What's your current mental capacity? Have you had mental health issues?
Is it for you, are those questions really baseline questions?
Yes.
It's sort of like the floor. You need to know, if I know that your name is Jane Doe, I'm the judge, and I ask you your name, and you tell me that your name is Sam Smith, then I may know that there may be a competency question.
I think that's true.
Is a FRERETA inquiry, in addition to having a discussion about self-representation and what it means, does a FRERETA inquiry also involve a determination of competency in terms of whether your waiver is intelligent and knowing?
Yes. In fact, in the U.S. Supreme Court in JORDEN has said that it's an issue of competency to waive counsel, but the competency envisioned in JORDEN was two parts. It was competent and intelligent. And the rule encompasses all of it. So the questions both go to competency of a defendant, and they also go to whether or not the defendant is knowingly and intelligently waiving the right.
Well, I'm sorry.
Competence, it seems that we're conflating these two issues. Clearly, a defendant, a person accused of a crime, has a right, constitutional right, to represent himself or herself. Isn't that correct?
Yes.
So the issue is not whether the person has the ability to conduct cross-examination or the ability to conduct direct examination or select a jury or do closing argument. Those are not the issues.
That is correct.
So the only issue then is whether a person is intelligent or voluntarily waiving the right to trial.
Yes.
Pretty much the same way we would conduct a colloquy in a plea conference when a defendant pleads guilty to determine whether the person intelligently and knowingly waived his right to a jury trial and so on and on.
Yes, Justice. Actually, I think that's a very analogous situation because this court has held that it's not enough to simply have a form, a plea form, that the judge has to have an oral discourse, a personal one-on-one with a defendant before that person can waive a right to go to trial and enter a plea. Now, the rule also specifically requires that now, but that's what this court has held.
In your experience as a public defender, when there was a change of plea, pursuant to a plea conference or a negotiated plea or just a straight-up plea, is it customary for the trial court to inquire about the person's intelligence, about the person's ability to understand, and does age play a role in it? As having an 18-year-old man or a woman as opposed to someone who maybe is 25, 30 years old, does that play a role in the judge determining whether to accept the plea or not, or finding that the defendant voluntarily and knowingly waived his right to a jury trial?
No, I don't think age necessarily. I think some of the questions, and I haven't done trials in 15 years, but I was in trials for 10, so I do have some experience. I do think that in those situations, it's more of like an experience where the judge will ask questions about, do you understand this? What don't you understand about it? And we can talk about it. And I think that's what all of these questions are. As this court has said repeatedly, the questions in the model colloquy are a framework. There's no requirement of a script, but there is a requirement of a framework.
But there is a requirement under the rule to have a thorough inquiry.
Yes, there is.
I mean, that is an adjective that is specifically used in the rule, and it means a certain thing. It doesn't mean cursory.
I'm in complete agreement with that, Justice, and I think that is the concern here, is that as the district court indicated, its concern with Bowen, that if the court starts asking questions about age and experience and education, then the court is being viewed as...
Well, you can't consider, after the rule was changed, you can't consider age or mental condition, or if you only had an 8th grade education, as to if you make an unequivocal request to represent yourself. You can't use, i.e. the trial judge can't say because you only have an 8th grade education, you cannot represent yourself.
That's correct. The judge can't say you can't represent yourself because you won't be a good enough lawyer.
Correct. But you can ask those questions in order to do a thorough inquiry as to determine whether or not, and the rule specifically says, the accused's capacity to make a knowing and intelligent waiver.
I think you have to ask those questions.
Correct. You do have to ask those questions.
Yes.
You do have to ask something in order to determine and do a thorough inquiry.
And that was what was missing here. There were no questions asked. There was basically a form that set forth the dangers of self-representation.
Well, let me ask you.
Let me focus you on the question that was presented to us and ask whether you agree that the statement in our 2009 case that a trial judge must ask about age, experience, and knowledge of the rules of civil procedure is inconsistent with State v. Bowen and other precedent from our court.
And I assume Justice is referring to the Aguirre-Jacqueline.
Yeah, that's why I said the 2009 case, because I didn't want to try to pronounce it.
I was hoping
you did a
someone
better
would
job
correct
than I
me.
did. Yeah, that's it.
I do not think it's inconsistent. I think it's consistent. I think what happened with...
So one says you must ask about age, right?
Yes.
And the other one says there's no magic words that you have to do.
And there aren't magic words. I think that's where the confusion
Isn't
lies.
that a problem? I mean, so I'm a trial judge. I'm sitting there. I'm looking at a charging affidavit that has a defendant's age in it. I'm looking at the defendant. He could be 67 years old. And so I know what the general age is. And I have a colloquy that is sufficient to show the appellate court and certainly efficient to satisfy me that this person is competent to make the waiver selection that they're entitled to make under the U.S. Constitution. And yet that could be reversed because I forgot to ask on the record about the age, which I know and can confirm with my eyes. Wouldn't that be problematic?
It could be. I think, though, the court has covered that in saying that it's the essence of the colloquy. It's not that every single solitary question must be asked.
That would be inconsistent with a statement in our 2009 case, I'm still not going to use the name, that says you must ask about age and the other two things.
I think in another situation, what the court did is said that the trial court was able to show on the record the age of the client, or the trial court actually put forth this information without asking.
Absolutely necessary in every case that the trial judge be cognizant of the age of the defendant, the precise age of the defendant, in order to make a determination as to whether the waiver is voluntary?
I would say yes, and some of the reason is based on what Justice LAGOA said, is sometimes you ask a client, a criminal defense client, you say, how old are you?
I have no idea what your age is, but based on everything that you said and the exchanges that we have, I would have no problem determining that you would be competent to make any exercise of your rights that you wanted to make right now. Wouldn't you agree? I mean,
What
we're
if I
having a
said I
very-
was 11?
What if we're
What if I
having a-
told you I was 11 years old, or I told you I was 120? I think then your answer would be different. I
So
think
you're
then you'd
you're
have some
saying that
concerns.
we should say that we have to ask specific questions in order to get at what we can tell otherwise?
I think you don't need a script, but I think there are
I mean,
certain
because if you were going
areas.
to insist that you were 11, I don't think we would have had the
So
discourse
so
that we've
you're,
had
so you're
before.
saying that the question about age is a question to determine whether the person is competent?
Not necessarily. I think it covers more than one thing. I think it also tells the court, these are just basic questions. How old are you? I'm 40. Have you ever, completed your high school education? No, I stopped at 8th grade. Well, then that judge may have to take a little bit more time to explain to this individual what the right to counsel
Well,
means.
And if in this case, because we don't know, because no one asked him, the trial court judge gave him a written form, but the trial court judge didn't ask him, well, how far did you go in school? If he had said, I only have an 8th grade education, then perhaps then the question, as the first DCA said, well, it's superfluous to ask, do you know how to read? Well, maybe it wouldn't have been superfluous. In fact, it would have been a thorough inquiry, which is what's required by the rule.
That's absolutely true,
Well,
Justice.
in this
Counsel-
particular case, I mean, what's the relevance of the fact that defense counsel, who seemed to have had a pretty significant amount of interaction with this person, says, so I think that if he wants to represent himself, surely that's fine. I mean, what is the court?
I don't know that it has any relevance because it's not up to the defense counsel to make any type of determination as to whether the client is making a knowing and intelligent waiver. We don't know from this record what kind of interaction what they even had.
Wouldn't it be incredibly irresponsible if this counsel who has, it seemed like there was some interaction over the form and reading the form and initialing the form and everything, and you would think that they had enough interaction. I mean, the competency standard for this, it seems like it's pretty low.
Yeah.
If you look at the one case, it's talked about if the person has an extreme mental illness, that's kind of the outlier where.
Yes.
So if after all that interaction, the defense counsel says, so I think that if he wants to represent himself, surely that's fine. I mean, that it seems like the court should be able to have some comfort, given the low bar and given that we're not talking about competency to actually do a great job representing yourself. How, in this particular case, because I think that the issue of what the general rule, how do you balance thorough inquiry on the one hand with not having this kind of list of absolutely mandatory things? I think that's a tough issue in the abstract. But in your particular case, how can you say that the court here wasn't correct to view this as a knowing and intelligent decision?
Well, because of what Justice LAGOA said, there were no questions. It's not up to the defense counsel to have the discourse with the trial court and say, in my opinion, this waiver is knowing and intelligent, or in my opinion, this defendant is prepared to represent himself. That's a determination that has to be made by the trial court.
But
And we don't really-
doesn't counsel have a duty to raise to the court the competency or, incompetency? If the trial counsel has a reason to believe that the defendant is incompetent, doesn't that attorney have a duty to raise that issue with the court?
If he's incompetent to stand trial, yes, I think he does have a duty to raise it with the court, but that has no bearing on whether this is a knowing and intelligent waiver. And we have no idea really of their interaction. A lot of this is speculation. We know that they came in for jury selection, the client got a form, other juries were selected. There were at least 2 chosen while the client sat there. We don't know if he sat alone. We don't know if his lawyer was choosing another jury. He's a public defender. At some point, the judge said, oh, I see you're contemplating. You might want to talk to your lawyer. We don't know that he spoke with his lawyer. We have nothing on the record to indicate that. Later on, he is brought up, and the lawyer brings him up and says, yeah, he signed and initialed the form. We don't know what occurred between them.
If I could back up a little
Sure.
bit. So as I understand it, there's a 2-part inquiry for Ferretta, correct?
Yes,
Part 1 is what?
competence.
Right, you have to ask about competence. And
Yes.
Part 2 is knowing
Knowing
intelligently,
intelligent,
waiving
yes.
the rights.
Correct.
2 separate inquiries.
Yes,
Then we have a rule that implements that, correct?
yes.
And what did we say about the first part, about capacity or competence?
We said that we have to go through this framework of questions to find out
Well, that's
if
not
he's
really what
competent.
we've said. We've said it needs to be a thorough inquiry of the capacity to waive your rights, correct?
And yes, and this court has said using a framework. So this,
So what in this colloquy, and that's what I'm focused on, so put aside,
Yes.
put aside age, experience, and understanding, because I think you have a hard time convincing us, at least me, that those are required. But,
Okay.
but where I'm stuck on is whether what could be thorough about what was asked here. So taking the form on its face, even in a written form, is fine. What about this went to capacity, went to a thorough inquiry of capacity? Was there any question asked?
There was no question.
Well, there's at least one, I think, right?
There was,
He has to
did
be
you read the
understood.
form real carefully?
Did you read it and understand it?
Well, not did you understand it, did you read it real carefully?
Well, in the form itself asked, did you read and understand?
The form itself, the person had to sign. As being a criminal defense lawyer all these years, I've had cases where my clients have signed plea forms, and when you go up there, the judge says, did you read it? And they said yes, and I have to say, no, judge, I read it to him, because he can't read.
I guess my question is, other than the understanding, at least in the written form,
Yes.
is there any thorough inquiry of capacity at all?
There was none.
Forget age, experience, understanding of rules of criminal procedure, anything.
No,
How could it comply with the rule then?
it could not.
Isn't that the real issue?
Yes.
And
I
it-
believe in
and-
this case it is.
And I'm going to ask the state, so I'm just letting you know. The capacity, capacity has a certain definition, and it means something, and capacity means an individual's mental or physical ability. So when the rule says that you have to have a thorough inquiry of both the accused apprehension of that offer and two, the accused capacity to make a knowing and intelligent waiver, accused capacity means that person's mental or physical ability to make a knowing and intelligent waiver. And there were no questions asked at all regarding either mental or physical capacity or ability of this individual.
No, there were none. And the concern is, if we have a form which sets forth the training and experience, all the benefits of having a lawyer and all the disadvantages of not having a lawyer, even if it's a brief two-page form, the court can take it one step further and list those other areas. List what is your age, what is your experience, blah, 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 and have the person just sign a form. And we can do away with all oral discourse. And that is the most important thing. We need to have a court actually speak to a defendant to get a feeling for, do they have capacity?
And again,
Are they knowing?
no one says that you have to have, read verbatim the model colloquy. That's not what is the requirement. The requirement, though, is a thorough inquiry into, one, the individual's ability, capacity to make a knowing and intelligent waiver, and then two, after that, then you have to advise him of the advantages or disadvantages of self-representation. You still have to do that as well.
Yes.
And the form did the second. It's the first part that's the problem, right?
The form may have done the second. I think that because we don't have any discussion about the form with the court, we don't know that it did it accurately or appropriately.
But at least on its face, if I disagreed with you and believe that the form is perfectly fine and this procedure is perfectly fine, the form did not, however, have any thorough inquiry of the first part that Justice LAGOA talked about,
That
which
is
is
correct.
capacity.
Yes.
And I understand you're making a process argument, and that may be enough, and that's fine, but there's nothing that you would point to in the record that would make us actually think that this person didn't have the capacity to understand the choice he was making.
Justice, I can't point to something that's not there. So if there's never an inquiry about it, then I can't point to it. If there hasn't been an evaluation, we have this issue with competency issues where there's maybe some indication at some point and the judge doesn't do anything and we are brought up to the court, but there's nothing on this record that I can point to now. So may I reserve the rest of my time? Thank you. Sorry.
It's okay.
May it please the court, Virginia Harris on behalf of the state.
Counsel, let me just ask you, because the rule specifically talks about a thorough inquiry into both, one, the accused comprehension of that offer, and two, the accused capacity to make a knowing and intelligent waiver. The definition of the word thorough means carried through to completion, exhaustive, careful about detail, painstaking, not superficial or partial.
Yes.
How exactly is this colloquy with the trial court judge and the defendant in this case anything other than thorough? Is it not, in essence, cursory, superficial? How does it address
Well,
the capacity?
I want to get into, there was actually 2 different times that the judge spoke to the defendant about this. This particular time that we've been talking about it, and again, before trial, when they start talking about the VOP being held with the trial at the same time. And I'm going to tell you the whole bird's eye view, and I'm going to answer your question. I don't want you to think that I'm trying to dodge it. But in this case, even though we don't have all of the proceedings, the record indicates that the defendant had been represented by the public defender's office for about 10 months. The judge would have also known, because one of the charges was a VOP, that the defendant was on probation and being supervised by a probation officer.
But in a Ferretta inquiry, you have to have a review, and there has to be something where you have an inquiry, and it's a thorough inquiry. It's not a thorough inquiry. In fact, you can't have a Ferretta inquiry 6 months prior, and then if the defendant right before trial makes an unequivocal request saying, I want to represent myself, you can't use the Ferretta inquiry that you did 6 months prior.
Oh, no, and I'm not saying that, but what I'm trying to get in before the court is what the judge would have known already.
Well, let's just talk about the transcript that's in front of this court right now. How is that a thorough inquiry? How is it rigorous, in-depth, exhaustive, meticulous, comprehensive? These are all the synonyms for the word thorough.
Right. Well, because the judge, first, I think that the act of asking for information didn't just come right then, but also from the form. The judge gives...
Well, how did the form talk about the use of the word, the accused's capacity to make a knowing and intelligent waiver? And again, the word capacity means an individual's mental or physical ability. What question whether in the form or orally, went to the individual's capacity, mental or physical ability?
Well, when he says he can read, when he says he read it real carefully, and
did
also
the trial court judge then do a superficial or a painstaking, detailed analysis of whether or not, in fact, he could read?
Well, when he does ask him that, he then summarizes the rights, again, sort of, when he says, and I'll just read it, he says...
Sort of, is that like a sort of a little bit pregnant?
Well, he says... first he indicates that he wants to know if he read it real carefully and kind of says, so I have to know if I need to go over it again. And the defendant indicates, yes, sir. And then he kind of summarizes it again and says, okay, and I'll say again, it's your absolute right to represent yourself.
Did he ask him after he says, did you get a chance to read over that real carefully, whether he knew or whether he had the ability to read?
Well, if you say, yes, sir, I read it real carefully, it's implicit that you would have to be able to read.
Well, but if he told you that he only had a 6th grade education, perhaps, I mean, this is very detailed language. Identify and preserve, uncover. I mean, if you only went to a 6th grade education, I'm not sure you would know what those words mean.
Well, what we kind of mentioned before is, actually, it might depend on the person. I mean, my dad was a lawyer, and I think when I was in 6th grade, I would have had a pretty good idea what a lot of this meant. But it doesn't matter how far a defendant went in school. It only matters whether he can read and comprehend the form.
That is true that you don't do that in terms of whether or not if you make an unequivocal request to represent yourself, but you still, as a trial court judge, have to determine whether or not that person has made a knowing and intelligent waiver, and that's based on that person's ability.
Well, and that's what the Godinez case indicates, and I believe it's footnote 13, competency does not need to always be determined.
So that's
it's only necessary.
But counsel, that goes to, and I know, and that was the argument used by the First DCA.
Right.
The problem is that goes to a determination of competency, and that's exactly right. In other words, you don't need to go through the trouble if you're not indicated. But our rule says something different. This isn't in the competency, where someone's competency is questioned, you are required to make a determination. In other words, there needs to be a physical order of yes or no.
Well,
counsel, 1 second. That's not what is an issue here. Our rule of 3.11D states that there needs to be a thorough inquiry of capacity, which is A, different than competency, and B, so it's different than competency, and B, isn't a determination, but the questions that need to be asked to go to it. How does Godinez then relieve us or is inconsistent with the rule, is my question
Well,
to
then
you.
I'll just go into exactly what was said when he spoke to him those last times. He asks him if he can read it real carefully and indicates, in other words, so I don't have to go over this again, which is indicating I will if you don't understand something. The defendant says, yes, sir. He then follows up by summarizing it, just in case the defendant didn't, and he brings up, you have an absolute right to represent yourself. I almost never advise
But counsel, we've read all this, okay?
Right.
All that oral inquiry goes to is the advantages or dangers of self-representation that's addressed in the form. But our rule specifically says, before determining whether the waiver is knowing and intelligent, and again, the waiver of knowing and intelligent still means that you have to have a thorough inquiry of the accused's capacity to make a knowing and intelligent waiver. So after you make that determination, then the court shall advise the defendant of the disadvantages and dangers of self-representation. Is it your position that the trial court only has to advise the defendant of the disadvantages and dangers of self-representation without making a determination about the accused's capacity to make a knowing and intelligent waiver?
I think when the defendant said that he had read it real carefully, and then when the judge goes over the summarizes it and says, have you had time and decided it? And he says, yes, I have. I want to represent myself.
Counsel, how is that even remotely, or even within the realm of thorough? I mean, that to me is the most comprehensive, superficial and cursory question. But when you read all the case law, all the cases talk about a Ferretta inquiry being 15 pages long, 10 pages long. I mean, they're thorough because that's what is required by the rule. It's a thorough inquiry, which means it's not a gloss. You don't get to just gloss over it and pretend and just do a superficial inquiry.
He talks to him another time, though. And so then prior to trial, they have a discussion about whether or not the defendant would want the defense attorney on the VOP. And the defendant initially says, yeah, well, we can keep him on the VOP. The judge then has a discussion with him about these are being held at the same time, and he's really explaining you can't have hybrid representation, but he doesn't say it like that.
But the discussion about Ferretta and him representing himself is done on January 11th of 2016. And then at that point in time, he says, okay, you're going to represent yourself.
And he says, actually, we're going to talk about this again before trial. And then he talks to him again before trial, and he asks him again. The defense attorney then says, we need to discuss this VOP. The judge then has a discussion with him to make sure that he understands that they're being held together at the same time, and that he can't have him and his lawyer both doing that. That would be hybrid representation, even though he doesn't use that term. And the defense attorney, who never indicated previously that she thought the defendant misunderstood, said, I do think, he's a little confused about this. So then they take time and explain this to him, the judge, and he says, look, I can do this separately, but this is really based on the same evidence and the same witnesses. It would be really inefficient.
And again, did it go into the discussion or an analysis of his capacity to make a knowing and intelligent waiver? Did he ask any questions pertaining to mental or physical ability?
Well, I don't think, I'm not aware of any case law that says that a judge has to ask about whether or not he has a mental illness in order to
That's not the
determine that.
question. The rule specifically says that you have to make a thorough inquiry about both the accused's comprehension of that offer and the accused's capacity to make a knowing and intelligent waiver. And the word capacity has a specific meaning, and it means mental or physical ability.
Well, I think the judge is making that determination based on his tone and his demeanor, and the fact that he's been seeing him throughout. I mean, it's not a high standard, but even this court doesn't have, when it says what questions you have to ask, has never indicated that you had to ask questions about a defendant's mental illness. I mean, you can represent yourself.
No one's asking about mental illness. It's a question about whether or not you have the capacity to make a waiver. So therefore, you have to have a baseline to ask questions to make a thorough inquiry as to whether or not that person is making a knowing and intelligent waiver.
I guess I don't want to ask you questions, but I need clarification on what exactly do you think the judge would have asked this defendant that would have told him?
Can I ask you something?
Sure.
Do you think that, it seems like there's a potential for there to be some tension between our rule with this thorough inquiry language and the right that was established in FREDA itself, because I understand what the text of the rule says, but it seems like if you read that too literally, you could end up eliciting a lot of information that if you then used it to deny someone's right to
Right.
represent him or herself, you'd then be, you'd flip over into the other problem. So,
And that's exactly what happened with Bowen. I mean, we had a rule before that suggested, in 1973, that you could deny the right based on age, education, mental capacity. And then FREDA came out afterwards, which is different than that. And then much later, Bowen came out in 1997. And Bowen suggests that's incorrect and relies
How
on
is-
FREDA. And then
Counsel, how is that though inconsistent, is what I'm asking. And I asked you this before and you never quite answered it, and then Justice
maybe I'm
Muniz came
sorry,
in.
I don't understand what you're saying, but I mean.
Well, let me explain it
Okay.
better then, because then I'm not doing a good job. So Justice Muniz said that there may be tension between our rule, 3.11 subsection D's requirement of a thorough inquiry into capacity to waive the right. That's what the rule says. FREDA says something. What does FREDA say that's inconsistent with that?
Well, FREDA and some of the case law from here indicates it's based on your general understanding of the rights. And then.
What does Godness say? What is the two-part inquiry that Godness said
Well,
you must
it
do?
does say that, what she said about competence and the ability to understand, but then in the footnote it drops, we do not mean to indicate that competency has to be determined in every case, and says, and I believe it's footnote 13,
here's exactly
only
what-
when reasonable doubt.
Here's exactly what footnote 13 says. It says, a court is not, quote, required to make a competency determination in every case in which the defendant seeks to waive his right to counsel.
Right.
A competency determination is only necessary when a court has reason to doubt the defendant's competence.
Right.
There's a difference between, is there not, a determination of competency, which is required in the competency setting, versus an inquiry into competency. One is, inquiry is, you have to ask questions about it, and then when you only have a doubt, must you make the determination.
But if you, I guess my position would be that, what exactly could a defendant say that would make a judge say, okay, you don't have the capacity? I mean, if he just said, for example.
Because the question is, do you have the capacity to make a knowing and intelligent waiver? And so and frankly, maybe most of the times, a trial court judge will find that the person has the capacity, because FREDA has made it, Indiana versus Edwards has made it clear that you can't, whether or not they're going to be a good attorney for themselves is not the question. So if you have an 8th grade education, you still have the right to represent yourself. The question is whether or not the trial court judge still has to make a thorough inquiry as to the person's capacity and ability to make that determination. And most of the times, I think the trial court judge is going to find that they have the capacity, because the issue is, do they have the capacity to make the waiver? And so therefore, you ask the question as to whether or not the baseline questions, which is, do they have just a general understanding?
Right.
And so if I ask them the question, do you want to do this? And they say yes, but if I ask them another question that's a baseline question pertaining to age, or something that the trial court judge knows exactly that the answer should be X, and if the answer is Y, then maybe there needs to be a further examination and inquiry into capacity.
Well, my position is that it's a low standard, and that a judge can make that determination by observing the defendant.
But how's that an inquiry?
Well, I mean, he's asking him questions, he's just not asking specific questions.
But the inquiry has to be targeted to capacity. So, like, I know, because you've been here before, you mentioned that you were a prior defense counsel.
Yes.
And I'm sure you took plea colloquies all the time.
Right.
And Justice Labarga asked you about this. In a plea colloquy, Isn't A, required to find capacity, and B, what questions are asked in every single plea colloquy to determine capacity?
A plea colloquy is different, and this is mentioned in the United States Supreme Court precedent, because a plea colloquy, a defendant is coming in and he's pleading out and the case is done and it's over, and so a judge needs to have more information about that.
There's no doubt about that,
With the trial, he's going to continue to watch.
There's no doubt
it.
about that, but that goes to the rights, not to the inquiry of capacity. Capacity, the same thing when you come into a plea colloquy, you have to make sure that this is a competent defendant in front of you. So you ask some questions, don't you? What are the questions that are often asked?
But the fact that he...
Can you answer my question? What are the questions that are often
that
asked?
are in the plea colloquy?
Sure.
I mean, they ask him if he's ever suffered from a mental illness, if,
Right.
you know, he can read and write.
If
Are you under the
is on
influence of any
drugs?
alcohol, drugs, or
Right.
narcotics?
Well, but in this case, the defendant, I'm not saying defendants could ever get anything in jail, but I mean, this defendant is incarcerated. But, I mean,
He could have gone to the infirmary and they could have given him some medication. I mean, correct?
Yeah, well, even if they gave him medication, though, that wouldn't mean that he didn't have the capacity.
Well, perhaps it would have had the capacity, because if they told him that they gave him Valium or they gave him something, then perhaps I would not be, if I'm the trial court judge, I would say, we're going to have this inquiry, we're going to reschedule this inquiry because I don't believe that you're going to have the ability to answer these questions.
Except that, I guess where I'm differing from you is that I think that the judge, based on watching the defendant and all this time, I mean, this is like docket sounding. It's not like this is the first time the judge has ever met the defendant. That a judge can determine capacity based on his tone and demeanor and ability to answer any questions that he's asking him, and that it doesn't have to be a specific question about have you ever been treated for a mental health disorder. In fact, that really doesn't tell you. I mean, I can tell you I've had quite a bit of experience with mentally ill. I was actually a public defender for about 7.5 years, and I've never had a client, even an incompetent one, that could not tell me how old he was. I mean, I'm sure that's happened before, or how far he went in school, but I think you get the information about whether someone is off by how are they looking at you? Are they responsive to you in general? And you can get that from any kind of dialogue. And another important thing...
So let me ask you a question. If you had a defendant who was present and you later found out that in fact the defendant was on some kind of drug, whether it was heroin or ecstasy, do you believe, just by observing them, that they would have the capacity or the ability to make a knowing and intelligent waiver?
If he was on heroin right then and I knew that?
No, you don't know that because you don't ask. You're the trial court judge, and you make the same inquiry here, which is none. So you don't ask the question as to whether or not you have taken any medication.
But this defendant wouldn't be on an illegal drug.
I'm not
because he's
asking, but when we
incarcerated.
write something, we don't write something just for this defendant.
And
we write for the entire state of Florida.
And
so answer
I
the question,
agree,
please, counsel.
But that's a tension because the United States Supreme Court, like for example in Iowa versus Tovar, says that it is a case-specific inquiry. And so I do understand your dilemma. And in some respect, it would be easier for us if you just said, oh, you have to ask these questions and everything. Our concern is that when you mandate certain questions that have to be asked, then that makes judges think they can deny representation based on certain answers, which is what happened in Bowen. And you'll notice that Ferretta's been out since 1975, and the United States Supreme Court has repeatedly rejected any standardization of this. And even in Edwards, when the Indiana tried to ask them, look, couldn't we at least have a requirement where if a defendant won't speak coherently to the judge or the jury that, he has to have a lawyer? And the court says, no, we're not sure how this is going to work. And it's because it is a case-specific inquiry, and the court is concerned about judges doing what they did in Bowen, thinking, well, we must ask these questions, which must mean we can deny representation based on
Do you
certain
believe
answers.
it's appropriate for a trial court judge just to make a colloquy in writing?
Not just in writing. No, you would definitely have to inquire about, like this judge did, where he said, did you read this carefully? And he indicates that he could go over it again. He doesn't say it exactly.
Well, do you believe that based on this record that this court could determine that this defendant, in fact, was able to make a knowing and intelligent waiver?
Yes, I think that we reached a constitutional minimum, and it is not as, Justice MUñIZ says, it's not a high standard.
How do you know in terms of capacity that this person actually understood because they weren't on any kind of medication or anything like that, or that they actually had the capacity to read?
It would be reliant on the fact that the judge was observing his tone and demeanor, the judge was asking him questions, and he was responsive, he was conforming his behavior in the courtroom, and his lawyer, the record does indicate
you could be conforming your behavior because you're on medication.
Well, I mean, that doesn't mean that you don't know what you're doing. In fact, some defendants, specifically ones
Well,
that
why do you ask that question in a plea colloquy? You ask that question in a plea colloquy because you want to make sure that the plea that's being taken,
Right.
if that person is under any medication, is a knowing and intelligent waiver, and there can't be made any argument afterwards.
And the United States Supreme Court, and I think it was their concurring opinion in Godinez, and the First District talks about this as well, talks about the differences between a plea and the case being done and over with. And that's not the end of it. A judge has a legal obligation to order a competency evaluation if there are reasonable grounds to suspect that the defendant is incompetent. So if a defendant, it's not over with after this. The defendant goes and he's conducting his defense in court. If there's any reasonable grounds that he's incompetent, the judge is required to act on this. So there's an additional protection there for a trial that there isn't for a plea. And the fact that this has occurred at a much later stage in the proceeding means that we know a lot more about this defendant. I mean, the progress docket indicates that there were numerous status conferences, pretrials. Apparently there was even a plea hearing set that I guess didn't work out. We don't have the actual hearings. And that this guy was supervised by a probation officer. There's nothing in the BOP affidavit that indicates that he has any problems with competence. And the judges mostly rely on lawyers to give them this. This lawyer never indicated there was any problem. And there is an excerpt from jury selection where...
This lawyer affirmatively said, they didn't just not indicate that there was a problem.
Right.
They affirmatively said there is no problem.
But there is case law that says that a defense lawyer cannot stipulate to someone's competency, correct?
But it's not that he's relying on her stipulation. I'm saying most of the time, unless the defendant comes in acting pretty bizarrely, the judge would be relying on a defense attorney to tell them about this.
But the rule specifically says it's for the court to make a determination, and that's it's for the court, not for... So they have to, the court is the one that has to make a thorough inquiry. You can't rely on defense counsel.
But of what? I think the judge had a sufficient dialogue with this defendant at that time and right before trial that would have showed him the defendant had the capacity.
Counsel, you've gone over.
Yeah, I'm sorry.
We caused that.
Sorry.
Okay. Thank you.
Okay, thank you.
Counsel, could I ask you a question? Could you articulate a manageable standard that would govern whether the inquiry has been thorough, that would be, that a trial court could be confident that they were meeting that standard and that appellate courts could consistently apply?
I think it's the model colloquy. I think it doesn't have to be word for word, but I think it needs to cover the topics that are mentioned in the model colloquy.
So you think that if a judge doesn't go through the model colloquy, that that's more or less, that should be per se reversible error?
More or less, yes.
And
I think there could be an instance
you
where-
think that that's what the law should be, or do you think that that's what the law is today?
I think that's what the law should be. I think right now we have this court saying the model colloquy is a framework. I don't think the court has gone so far as to say the model colloquy, whether or not it's word for word, is a requirement. But I think this court...
If we were not inclined to adopt that, can you think of another manageable standard?
I think the one you have now is manageable. I just think it was misapplied. I think the standard is that you use the model colloquy as a framework and you conduct a thorough inquiry. I just think the First District Court got it wrong. I think they got it wrong in this case. They got it wrong in Edenfield. And I think that's because they did not do a thorough inquiry, which is already required. And this court has said, these are certain things that you should talk about, and the idea is to get a discussion with this individual to determine if this individual, this person, as respondent said, it depends on the person. And that's the whole point.
Let me ask you this. Would you agree that this is a rule of procedure that we're looking at?
Yes, I guess,
Okay.
yes.
Now, this is a rule of procedure designed to affect the constitutional standard that has come down to us from the U.S. Supreme Court,
Yes.
correct?
Yes.
So when we apply this, we must always be mindful of the constraints and limitations and the contours of what's come down to us from the U.S. Supreme Court. Is that correct?
Yes.
Okay.
Yes, which is why I would say the model colloquy is the way to go. This is what the court asked for after Bowen, and this is what was put together, and the model colloquy is quite thorough, and I think would take care of a lot of these issues if it was followed, as this court has recommended time and time again.
So what exactly, I mean, I'm having a hard, it seems like there's a lot of questions, though, that are eliciting information that at the end of the day doesn't really matter. I mean, how do you define having the capacity to make these decisions?
Is there a mental or physical limitation that prevents you from being able to understand? And then the second part is this a knowing and intelligent?
Stop at that. So what
Okay.
does that mean? What is the court trying to figure out? I mean, it's obviously not, it can't just be sort of an educational level or your overall intelligence. I mean, it seems like it's almost more like, are you rational? You know what I'm saying? I mean, I'm having a hard time understanding what decision the court is supposed to be making here.
My time is up, may I answer?
Sure.
Okay, I think that what the court is looking at in that instance is, as Justice LAGOA said, is the person having a mental episode such that they don't have the capacity to make the decision right now? Is this a schizophrenic person who's not on their medication? Is this somebody who has had a fall and hit their head at the jail and is now unable to firmly understand what's going on? It doesn't mean that that person 5 days from now may not be in a different capacity, but right now, when the waiver is being made, does that person mentally have the ability to make that decision?
So with the question, are you on medications right now, would that suffice?
Not alone, but I think that's a good start. I
If
think
he
that's
says,
necessary.
If the defendant says, I'm not,
I think the court,
where else can the judge go from there?
well, if the court is asked, have you ever been diagnosed with a mental illness? Yes, I have. Are you on current medication right now? Yes, I am. What is that medication? That's the whole point of the inquiry, is the back and forth so that the court can determine where this person is mentally.
But I can understand where the answer is yes as to having a mental illness, and yes, I'm on medication. What happens when the defendant says, no, I don't have any mental health issues? No, I'm on no medication. Is that the end of the inquiry?
If the court is satisfied, if the client has said repeatedly, I don't have a mental health issue, I'm fine, the court does not see any indication of many mental health problems, and then has moved on to the other issues of knowing and intelligent, and the court makes a finding, then I think that court does not abuse its discretion in making that finding if it's done the thorough inquiry.
But sometimes the answer, are you on medication, that it's a yes could be the good answer.
It could be.
Yes, I'm on medication, and that's why I'm not having a panic attack right
Hence the
now.
necessary follow-up. That's the whole point of the inquiry, is one question may lead to another or it may not. The court has to determine where that client's standing at that moment in time to make that decision.
So it almost sounds like it sounds like what you're talking about does not sit easily with a per se reversible error standard, because it seems like if you're going to have all these boxes that you have to check, and the failure to check a box, which there's no way from these questions and answers that a court could possibly know all the different paths that the questioning could go down, and where a future reviewing court would say you didn't ask the perfect question. I mean, it seems like this would then demand more of a harmless error case by case kind of thing, in which case someone like your client, where, I mean, it seems pretty clear that you have, a very plausible kind of process argument, but not much that you can point to show that this person was actually prejudiced by anything. I mean, so what do we do with that?
Well, he represented himself and he lost and he got 10 years in prison, so
Well, I mean, that's,
I think that's prejudicial. But,
you would agree.
so, my time is up. Do you want me to continue? or-
No, go ahead.
I'm sorry.
No, I mean, I'm finished.
That's finished? Okay. Thank you. We ask that you quash the decision at First District Court. Thank you, Justices.
All right, we thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All right.